Hello, this is Steve Daugherty, attorney and CEO of Montana Elder Law. So I want to share with you what I call Estate Planning 101, and it's just kind of a basic understanding of what is estate planning. So when you come into our first meeting, you'll have a basic understanding and also allow you between now and then to come up with some questions. The first thing I'd like to talk about is really there's three ways to die from an estate planning perspective. One is we can die with no documents in place. That's called dying intestate. And if we die intestate, then the state of Montana has a set of statutes that basically they give you an estate plan. And it's not always the estate plan that you want. Okay, so we don't want to die intestate. Of course, that's the reason you're coming to see us. The second way you can die is with a will-based estate plan. The third way you can die is with a trust-based estate plan. So what are the differences? Well, there's pros and cons to each, but we'll start with a will-based estate plan. The pros of a will is that it's simple, very straightforward, and reasonably inexpensive to create. The downside is the administration is more burdensome. We're limited on what we can do with a will. We can't provide any creditor protection to our heirs. And the big thing here is the only way we can validate a will is that we have to go through a process called probate. So what is probate? Probate is a state's process for closing the books on us when we die, for lack of a better definition. The process of probate is if I'm hired to do a probate for a family, we'll file documents with the district court in the county of the decedent, and we're basically opening up, we're petitioning probate, and then we go through a very lengthy period of statutory time periods and kind of going through the courthouse's rubber stamp process. We're going to advertise a death notice to provide legal notice to creditors to come forward, and that way if the decedent owed any money to anyone, then the creditors have the opportunity to come forward in court and say, Joe owed me $1,000, and they have 120 days to do that. At the end of 120 days, they're forever barred. So the process is good in that we can prohibit future claims, a lot of them being frivolous perhaps, showing up and saying the decedent owed me money. Well, the downside is it's a statutory minimum of 6 months to go through probate. And then we have to do an appraisal, so we're trying to figure out how many assets did the decedent own, how many liabilities or expenses does the estate owe. And so we're just kind of, we're doing the math there. We're taking the assets and we're paying off the debts, and then with whatever is left, it's distributed per the terms of the will. Which is good, but when we close probate, the assets come out all at once. And so if the heir is 18, 19, 20 years old, they may get all of their inheritance at an inadvisable age, right? How long does it take? I tell clients that if I can close probate in 12 months, I've done a good job. So it's not that it really takes that much time from us to actually submit all the paperwork and go through it, but it's a clunky process, and it's kind of like going and buying a license plate, right? So you're sitting down there for 22 minutes waiting for your number to be called, and then you go up and you spend 1 minute writing the check. So that's the equivalent of probate. So whenever we go through the courthouse, it's going to take more time, and if it takes more time, it's going to cost more money. So a lot of people want to use a trust simply to avoid probate. So that kind of takes us to the next option. The third way to die is dying with a trust. And there's all kinds of trust available. There's revocable trust, irrevocable trust, and a slew of everything. But really they fall into two categories, irrevocable and revocable. You also hear irrevocable and revocable. I use the words interchangeably. And as the name implies, a revocable trust is just something that can be changed during your lifetime. And really, a revocable living trust is just a substitute for a will. Well, the good news with the revocable living trust, two things. One, we don't have to go through probate for it to be administered. So sometimes we're administering a trust in a matter of 60 days versus 360 days. Okay? As you would expect, that's going to cost less. Why? Because it takes less time by avoiding probate. By the way, probate's a public process. If your neighbor dies, you can go down to probate, ask for the Johnson file, and they will give you that file and you can read all of their business. Not that you're going to do it, but there are scumbags out there that prey on the elderly and the that inherit money. So how do they find that out? They go down and they look at the probate files. But I don't want to try to cause any unnecessary concern. My point is it's public record. Trust or not, they're handled privately. We don't go through probate. They're actually governed by contract law. So it's just kind of executing a contract. Now the difference is if you handle something privately versus publicly, which one do you think is going to cost less or more? Well, again, if you go through the court, it's going to take long. If you go through the courthouse, it's going to take longer. I tell people whenever you go through the courthouse, add a 0 to what it would cost to do privately. So with a trust administration, sometimes I'll have a multi-million-dollar estate that I'm administering via the trust, and it's going to cost less than a $100,000 probate case. It's just a matter of time and what takes the longest. But the real value for most people who are using a revocable living trust is it allows our heirs to inherit with some protection. Okay? So back with a will, if Johnny inherits $250,000, that goes into his name. If 2 years later he goes through a divorce or runs over a van full of trial lawyers, well then the inheritance is probably going to be gone, right? If he files bankruptcy, makes some bad business decisions or regrettable investments, it's gone. Now with a trust, what we might say is 20-year-old Johnny, maybe we give him $50,000 outright to give him a little leg up on life, but perhaps we're going to hold the other $200,000 and give that to him in some increments over the next 10 years. So he gets more than one bite at the inheritance apple, so to speak. And until he inherits that and it goes in his name, whatever money is retained in that trust is protected from future divorces, lawsuits, creditors, etc. Why? Because it's not in his name. If he gets sued, the creditors will go after whatever it is that he owns and what is in his name. Well, if the $200,000 is still in the trust, he doesn't own that, so he doesn't lose it. That's the number one reason people are using trusts. Now, not because they got multi-million-dollar estates, it's because they just want to make sure that their children they do not lose their inheritance in a divorce. That's the big one. A little bit about trust. A trust is just a contract. All right, it started back in the old days of the knights, and so the knight, usually single, rolling stones, right? They didn't have a home, but maybe they had a bag of gold and a lot of armor, so they would go off and fight in the Crusades or whatever other mercenary outing that they've gone upon, and they leave their bag of gold with their trusted friend. And the idea is they have entrusted this bag of gold with their friend or favorite bartender, and they say, hey, if I don't come back, I want you to give whatever in this gold to my dear mother and keep a few shillings for yourself for the trouble. They come back from the Crusades, they get their bag of gold, and they throw a few shillings to their friend and said, thank you very much, and they do it over and over and over and again. And that is actually the foundation of trust law. That was just a verbal contract, a verbal agreement, right? Well, today it's the similar thing. It's that we're going to put it in writing. And so there's three parties to a trust. There's the grantor, which would be you, the person that hires the attorney to set up the trust. There is the trustee. That's the person who manages the trust. And ultimately, the third party is the beneficiary. This perhaps would be your children who inherits whatever is in the trust when you die. So with a revocable living trust, you are the grantor. You put the assets in this trust, but you are also the trustee. So you're also managing the assets. So that is no different than if you own assets individually, right? So if you have some investment accounts, bank accounts, or a home that's in your personal name, you manage those assets. And a will would govern those upon your death. With a trust, what we're doing is we're granting into the trust the legal title to those accounts, maybe not all of them, maybe just some, as well as the real estate. We put that in the trust, and then with a revocable living trust, you're the trustee, and then you manage that. You want to pull it back out of the trust? Fine. We don't record the trust anywhere. They're not public information. They're private. And if you want to change it, just like with a will, you go to your attorney and say, hey, I want to amend this, etc. And then upon your death, what we call the successor trustee, that would be the equivalent of the executor of the will. This is the person who you have assigned to, who you've nominated to handle your estate once you die. Could be a child, could be a sibling, could be the trust department at a bank, depending on your situation. But upon your death, there is a successor trustee to succeed you in managing your estates. And at that point, upon your death, the trust becomes irrevocable, and they're obligated to honor the terms of your trust. Same thing with your will. If you have a will and you die, no one can come in there and change that, right? So if you say, upon my death, I want my kids to get 20% outright, but the other 80%, I want them to get, when they're 30, 40, 50, or whatever's appropriate in your case. You can also treat the kids differently, right? Some kids, it might be fine for them to inherit outright. Other kids, maybe we want to do a little parenting from the grave. So trusts are very flexible. We can't do this with a will. Now, if you are married, I typically do a joint trust. So you both have one trust, not two, and then it does not become irrevocable until the survivor dies. Upon the survivor's death, so it's the surviving spouse's death, then it becomes irrevocable and go to the kids that way. Now, that's revocable living trust. That's a revocable trust. The other world is irrevocable. And this is for more advanced types of asset protection. The majority of the trusts in the world, or in America, is probably about 80% revocable living trust. And all it is a will substitute. You avoid probate, and you're able to kind of keep some strings on the assets after you die, providing creditor protection for your kids. So that's the three ways that you can die from an estate planning perspective, and the pros and cons of each. Now, people often ask me, well, is it worth the extra investment to do the trust? And my response has always been, they're probably going to cost about the same. You're going to pay less up front for a will than you will for a trust, but upon your death, the administration is going to cost more. So it kind of depends, but in the end, if you take the creation and the administration costs, they're probably going to balance out. So don't let the tail wag the dog here. Don't make your decision based on the fee or the price. Base it upon what's appropriate. What's the appropriate way to get your assets to whom you want and in the way that you want. So that gives you an idea of the quote-unquote death document, and that seems to be what everybody's really focused on. But equally important are your incapacity documents. So what am I talking about? If you become incapacitated, whether that's from a car wreck and you're in a coma, or you're older and you have a stroke or dementia, or whatever the issue is, if you can no longer make decisions and control your money or your body, at least 24/7, then we need to have someone that has legal authority to make decisions on your behalf, whether that's paying your power bill, rent, mortgage, filing your tax return, or dealing with hospital personnel. And so if we don't have anything in place, then we have to go through a process that we often refer to as living probate. So what does that mean? We got to go back to the courthouse, and we got to get a family member or whomever appointed your conservator. The conservator's role is to conserve your money, to protect your assets. And then we got to have someone appointed guardian to guard your body. Okay, so one is for the money and two is for the body. And that process, it can run $3,000, $4,000, $5,000, and we are leaving it up to a judge to decide who's going to serve those roles. So in some families, it's kind of a no-brainer who's going to serve that role, but unfortunately, there are times where it gets contested, particularly with a blended family or a second marriage, and it can be tens of thousands of dollars as the kids fight with the second spouse of the incapacitated person. So when we're doing all this, we're trying to answer all of the questions up front so no one has to make any decisions later. You're just trying to create a recipe to bake the cake, whether that's for incapacity or upon your death. So instead of going through the courthouse to have someone appointed as a legal representative, we can do that today with simple powers of attorney. Okay, and there's different types of powers of attorney, but a durable power of attorney that allows you to appoint, whether that's your spouse or most trusted child or whomever, the person that you trust most, could be a sibling, to make those decisions, to handle your money and pay your bills, file a lawsuit, file a tax return on your behalf if you're out of it. And what we want to do is we want to have successors. I like to always have 3. And you don't have to make this effective immediately if you're married. Oftentimes we do. We want to appoint your spouse effective immediately. That way, if you're out of town, they can actually sign documents. But I don't want my clients' children to have legal authority to write checks on their behalf unless my client has become incapacitated. And the same thing for the guardianship. It's with the power of attorney. We just call it a healthcare power of attorney. And so whomever you have designated as your agent, they can speak to the doctors or the medical personnel, and it's not end-of-life decisions that they make, it's quality of life. Okay, so what am I talking about? I'm talking about they can say yes or no to a medication, yes or no to a procedure or a transfer of you. And these are just a few $100s versus a few $1,000s. Remember when I said, hey, if you go to the courthouse, add a zero to what it costs to do privately? And that's exactly, that's case in point, right? The other incapacity document that is perhaps one of the most important estate planning document that you can have is your living will. My living wills, and I have several doctor clients who've reviewed them and they like them, and it's evolved over the years, but my living wills, ours at Montana Elder Law, state if the client, if I, have been diagnosed as being in a permanent, irreversible vegetative state, and the medical definition of that is there's no brain activity, that you're being kept alive by a respirator. We don't want our family have to try to figure out what to do. We don't want to pass on this horrible, burdensome decision to people we love. And so this is you making a decision today that says, if I have been diagnosed in that position, I'm instructing, I am directing the doctor, the attending physician, to not keep me alive artificially, and oh, by the way, administer any kind of pain-relieving procedure or medication so as to alleviate my suffering. And the important thing here is that your family does not have to make this decision. A lot of people have to make a decision. And it may be the wise, loving, prudent decision to make, but perhaps one of the most painful they'll ever have to make. So what we're trying to do, again, is we're trying to create a recipe to bake the cake, whether that's for incapacity or death. We want to try to answer any possible questions that could be asked later. And so our loved ones, all they have to do is follow our instructions. Now, these incapacity documents also include what's called a HIPAA authorization. It's just you're authorizing the release of your medical records to people you designate, typically your immediate family. So we can try to eliminate all of the paperwork that oftentimes accompanies an emergency situation. All of that together, you may have heard characterized as an advance directive. An advance directive is typically one document that kind of does all of that, but it's much more brief and concise. Mine has a little more horsepower, but you may have an advance directive that's appropriate with St. Pat's Hospital, but St. Gary's Hospital in Nebraska may not accept it. So when you have an attorney draft all these documents for you, they're going to work anywhere from Miami to Anchorage. And they're much, much, much more detailed. So your incapacity documents are every bit as important, sometimes more important than your death documents, whether that's a will or a trust. One last thing I want to talk about, and I think that this is as important as any estate planning document that you have. And it's one that not that your attorney prepares for you, but it's one that you write yourself. And it's a letter. It's a simple letter. It could be as simple as a checklist that just says, these are the people to call. I have a storage unit rented across town with a bunch of things in it. Here's the passwords to my important accounts. The gold's buried under the doghouse. Whatever is appropriate for you in your situation, what we're trying to do, again, is provide a roadmap or a treasure map so we eliminate the scavenger hunt. So at the very least, I want you to write a letter to your family. What I would prefer that you do is write something a little more heartfelt than some sterile checklist of steps for people to do to make the administration of your estate simple. One thing I forgot to mention is whether you do or you do not have life insurance. This is something that we can search for hours and hours and hours, and we never really know and get closure. When is it okay to stop looking for someone's life insurance? So that would be something you would put on that checklist, right? But again, what I would prefer you to do is to write a more detailed letter, a little something maybe more heartfelt. It's a good opportunity to say, this is what I stand for, this is what I believe in. If there's things that have gone unsaid between you and other family members or friends, it might be a great time to say it. So I share with people, I never knew either of my grandfathers. They both died before I was born, and I certainly didn't see any of their assets, but I would give anything today if I had a handwritten, laminated letter from either of them saying, you know, this is what I believed in, this is what I stood for, these were my values, because I'm sure I'd recognize some of those same qualities in myself, and I'd have that connection, and I would always have that letter. So do that for your family. A lot of times just saying, hey, call these people. These are the people that need to be called, and those are the ones that will be able to figure out the missing details. So hope this is helpful. We look forward to seeing you soon. If you have any questions, write them down and we'll address those at the meeting. Thank you.